Elliott Gabriel, please, followed by Raul Razo.
Okay, this statement is regarding the proposal before you. Regrettably, the City Council of the City of Oxnard has made little productive use of the Ventura County Human Rights Coalition's time, just like it's made little use of the $125,000 of the taxpayers' money on the losing idea of changing the city's name to Oxnard Shores. Through negotiations and personal outreach, our coalition had hoped to convince the City Council that a condemnation of SB1070 would send a clear message to the community. The City of Oxnard stands by the sacred principle that all men are equal, created equal, and are thus deserving of fair treatment, tolerance, and respect. We also made the observations that police enforcement of immigration law will drive witnesses and victims of crimes underground, forcing them to remain in the shadows, given the legitimate suspicion and distrust towards law enforcement, which are a natural byproduct of the law. And also that the exodus of unauthorized migrants and their families to adjacent states such as our own will place inordinate strain on the already revenue-strapped state of California and its social service providers. Instead, we were told with near unanimity that the Oxnard City Council has an ironclad rule which stipulates that it refuses to tell another entity what to do, regardless of the fact that the people of Oxnard are concerned by the attack on migrant communities which SB 1070 represents, and regardless of the fiscal and social impact which this attack will entail. The resolution which was recommended to this council by our coalition on July 20th was sidelined and replaced with one copied verbatim, just about, from Chula Vista. The resolution before us seems like a self-congratulatory maneuver on the part of the council which strikes us as meaningless and should therefore either be rejected or drastically altered. Given the existence of two gang injunctions within the city, which represent living, breathing examples of legislative aggression towards the rights of working people and families residing in the affected areas, I myself feel that the statement that the Oxnard City Council supports policies and actions that unite our community and not divide it is equivalent to the council granting itself a certificate of good conduct, which it has done little to deserve. Point 4, as Priscilla mentioned, which reads, investigating a person's immigration status and enforcing immigration law is primarily a federal responsibility, is subsequently negated by point 6, which states that law enforcement officers inquire about a person's immigration status only when that individual is arrested for or believed to be engaged in criminal activity other than a federal immigration violation. The strange and really apparent contradictory nature of these two lines combined really calls into question the true purpose of this resolution. And I do realize the culprits may lie in Chula Vista. In short, the outcome of our negotiations has proven to be a learning experience not only for some of us in the coalition, but hopefully for the people of Oxnard as well. The general style of the City Council of Oxnard is clearly pragmatic and flexible in terms of empty gestures and vague promises such as those contained in the proposed resolution. But this style does not in essence bear any practical outcome, contradicting the Council's permanent bias in favor of agro-industrial and commercial interests, police unions, and other entities which do benefit greatly from the harassment and exploitation of migrant labor. To claim that the Human Rights Coalition has artificially transplanted the debate or fear into the community is an idea which flies in the face of common wisdom and illustrates the distance between the Council and the community. It's the right of people targeted daily to feel anxiety, and it's purely natural.
Thank you.
Thank you.